we will be highlighting our written submissions. I'll try to avoid going into the details. I'll basically highlight the main issues, my lords. Dated dated 19th of June 2025. We have 7 key issues to raise. The first issue that I will raise relates to the improper joinder of the second respondent. My lords and my lady, the substance of my argument in this regard is that a distinction must always be drawn between Parliament and the office of the Speaker. My lords and my lady, Parliament is an organ of the Constitution that is separate and independent of the office of the Speaker of National Assembly. My Lord, the responsibilities imposed on Parliament as an institution are separate from the responsibilities imposed upon the office of the Speaker of National Assembly. It is therefore our humble submissions, my Lord, that not every violation committed by Parliament constitutes a course of action as against the Speaker of the National Assembly. And in this regard, my lords and my lady, it is our submission that all the allegations made in the petition do not constitute a course of action as against the Speaker of National Assembly. Therefore, the Speaker was improperly enjoined to this petition. My lords and my lady, the second argument touches on the jurisdiction of this court. It is our humble submission that this court lacks jurisdiction to entertain the petition. The argument, Lord, is anchored on Article 165 of the Constitution, which bestows upon this court jurisdiction to determine any question touching on the constitutionality of any law passed by Parliament, and also of any action that is being carried out by any organ of the Constitution. Lord, I separate these two limbs. One is anchored on Article 165, 1B, and the other one, D. The jurisdiction to entertain questions touching on constitutionality of any law must be separated from jurisdiction to entertain any question touching on the constitutionality of a bill. A bill, my lords and my lady, is not a law. And therefore, it can only be dealt with under Article 165(1)(d), which talks about jurisdiction to question or to entertain any grievance touching on the constitutionality of anything that is being done pursuant to the Constitution. 165(1)(d). D for dog. That is the jurisdiction bestowed upon this court to hear any question respecting the interpretation of the Constitution, including determination of the question whether anything said to be done under the authority of this Constitution or of any law is inconsistent with or in contravention of the Constitution. That is 165(1)(d), subparagraph Roman 2. My Lord, as far as that particular clause is concerned, it is our humble submission that the only constitutional question that can be raised has got to do with whether whatever is being challenged is being carried out in accordance with the procedures set out in the Constitution. Meaning that as far as that particular issue is concerned, focus has to be on procedural propriety. And it is our humble submission, my lords and my lady, that there is no allegation in the petition touching on failure to follow any procedure on the part of Parliament or on the part of all the other respondents named. Meaning, therefore, that the court would have no jurisdiction to entertain the matter even under Article 165(1)(d) Roman 2. My Lord, allow me then to move to the third issue, which is touching on the doctrine of separation of powers. And as far as this is concerned, my lords and my lady, it is our humble submission that this particular petition violates the doctrine of separation of powers. The Constitution, in its wisdom, distributes roles and mandates to its key organs and expects each of these organs to faithfully discharge their mandates without undue interference from the other organs. My lords and my lady, it is only after a constitutional organ has discharged its mandate that the question whether it has discharged it properly, legally, or constitutionally can be entertained. Any question challenging what it is doing before it accomplishes the task can only constitute interference. And that, therefore, is a violation of the doctrine of separation of powers. Lords and my lady, Parliament in this case has not completed the process of amendment that is challenged herein. Indeed, that process is still ongoing. It is therefore only fair that it should be allowed to complete the process before the question whether it has been done in violation of the Constitution can be entertained. What is being sought to be done in this petition can only be compared by an application made by a direction being given to court by Parliament, either to allow an adjournment of a case it is hearing or to allow a particular witness to testify. As long as the court is still handling a matter, the question whether it has been done rightly or wrongly does not arise, and no other constitutional organ can interfere. In the same manner, Parliament should be allowed to do its work without interference. My Lord, this is a point that has been determined in several matters, several authorities that we have made reference to. There's the authority of Mumu Matemu versus Trusted Society of Human Rights Alliance, the authority of Institute for Social Accountability and another versus National Assembly and 5 others, and the authority of Cabinet Secretary for National Treasury and Planning and 4 others versus Okoiti and 52 others. My lord, my lords and my lady, my fourth argument rests on the issue of violation of the doctrine of ripeness. Ripeness, my lord. It's a very inveterate principle that a constitutional grievance, or indeed any other grievance, must crystallize before it can be made the subject of litigation. In this case, my lord, the main question is that the intended amendment has not brought on board what the petitioner calls Constituency Development Fund. My lord, it should be appreciated that the process is still ongoing. Indeed, at the time of filing this petition, public participation was underway. There is no knowing, my lords and my lady, whether at the conclusion of this process, World Development Fund would have been brought on board. It is therefore clear that the petition was brought prematurely and it violates the doctrine of ripeness, and for that reason, my lords and my lady, it should not be entertained. And as far as this is concerned, allow me to rely on the case of the Attorney General and 2 others versus D and 79 others, a decision of the Supreme Court, otherwise known as the BBI decision, as well as the case of the Senate and 3 others versus the Speaker of National Assembly and 10 others. My fifth argument, my lord, is anchored on violation of the doctrine of exhaustion. My lord, it is also a very well-known principle that where a redress mechanism has been provided by law, then every effort must be made to take advantage of that redress mechanism before rushing to a court of law. My lord, parliamentary procedures indeed allow any member of the public to bring on board whatever concerns they think should be taken into account by Parliament. That is the essence of public participation, which is entrenched in Article 118 of the Constitution. In this case, therefore, the petitioner had the option of raising these issues before Parliament itself. If he felt that there are other matters that should be incorporated as part of the amendments, then the available opportunity for him was to raise the issue with Parliament, not to rush to court. To do so, my lords and my lady, violate the doctrine of exhaustion, and that this court therefore ought not to entertain the matter. My sixth argument is based on violation of what we call the political question doctrine. It is well known, my lords and my lady, that courts of law avoid delving into issues that are purely political in nature. The question as to which policy option is more desirable than another does not fall within the province of what this court ought to deal with. Policy choices, my lords and my lady, are made by political organs that have been entrusted with that responsibility under the Constitution. In this case, the petitioners are telling us that it would be more desirable to include what they call World Development Fund as part of a constitutional amendment. That is a purely political question. And it is one question which is best dealt with by Parliament. My Lord, the political question doctrine has been recognized as part of our constitutional doctrine in several decisions, which include National Assembly of Kenya and another versus ISA and 8 others. They also include, my lords and my lady, the case of Olili versus the President of the Supreme Court of Kenya and others. And finally, the case of Kenya Airports Authority versus Mitubel Welfare Society and 20 others, a decision of the Supreme Court, where it was held that courts should be reluctant to pronounce themselves on the desirability of policy choices. Finally, my lords and my lady, we also argue that the petition violates the doctrine of specificity in constitutional adjudication. Now, this doctrine requires that where an allegation is being made that the Constitution has been violated, then there should be a clear demonstration not only of the specific provisions that have been violated, but more importantly, how those provisions have been violated. My lords and my lady, this is the issue that was settled by the locus classicus decision of the Court of Appeal in the case of Anarita Karimi Njeru versus Republic. My Lord, the Court of Appeal clarified that any matter alleging a constitutional violation must demonstrate the specific provision that has been violated and how that provision has been violated. My Lord, in this particular case, we argue that the conditions set out in the Anarita Karimi case have not been met. There is no specific provision of the Constitution that imposes an obligation on Parliament to include World Development Fund in any constitutional amendment seeking to entrench the CDF into the Constitution. My Lord, allow me now to show why we contend that the allegations made in the petition, the allegations of violation made in the petition have absolutely no merit and should be ignored. We start with the allegations of violation of Article 27, Subarticle 1. What is the substance of this allegation? What the petitioner is arguing is that Article 27, Subarticle 2 has been violated because the MPs are entrenching CDF into the Constitution, which serves their interests, but they have ignored World Development Fund, which allegedly would serve the interest of the world representatives. But such arguments lack basis, merit, because it is also factually incorrect. It is not quite correct, my lords and my lady, to say that Constituency Development Fund serves the interest of the MPs and does not serve the interests of ward representatives or MCAs. Wards are located within constituencies. And anything that serves the interest of the constituency serves the interest of the ward. And therefore, such arguments, therefore, clearly lack merit. Now, the argument that omission to include ward representatives, ward development fund in the bill violates Articles 175, 201, and 203 by concentrating resources at the national level equally lacks merit. And this, my lords and my lady, is tied to what I've just said. It is not entirely correct to say that Constituency Development Fund is concentrated at the center, because all constituencies are distributed all over the country. And so such arguments is completely without merit. Indeed, members of the county assemblies have a role to play when it comes to determining which resources or which projects should be funded by Constituency Development Fund, just like every other member of the constituency, my lords. The allegations of violation of Article 10 on public participation is equally without merit, my lords and my lady. The substance of the petitioner's argument in this regard is that public participation has only been carried out with regards to the question whether it is desirable to entrench Constituency Development Fund into the Constitution, but no public participation has been carried out with respect to the question whether Ward Development Fund should also be anchored into the Constitution. My lord, such argument lacks merit for the simple reason that Ward Development Fund is not part of the bill, and there can be no obligation to carry out public participation with respect to a matter that is not part of the bill that is before the House. My lords and my lady, have therefore shown that there is absolutely no constitutional provision that has been violated to warrant the institution of these proceedings. And for those reasons, my lords and my lady, it is our submission that the petition should be dismissed. Thank you.
We'll do it in the open court. At 10.
My lord, you said the date is 22nd of October?
Yes, in the open court at 10.
Much obliged.